there is so much commonality across these state laws, there are going to be a lot of areas where the state AGs are going to be pursuing enforcement cooperatively across states. So a lot of the provisions that are in common, I expect multi-state enforcement.
Hey everyone, I'm Ron DeJesus, Field Chief Privacy Officer at Transcend, and today I have the absolute pleasure of having Representative Steve Elkins from Minnesota, who was essentially the drafter of the Minnesota Consumer Data Privacy Act, which is our 19th state law. If you think about it, the fact that as privacy professionals, we've had to deal with 18, now another 19th, it's quite the challenge for us privacy pros. And I know that you developed this law over the past nearly 5 years over multiple legislative sessions. So I'm sure you're really excited to see this finally go live on the 31st of this month, right?
I am absolutely excited.
Yeah, and I was doing a lot of research before this session and lots of really novel things with this law, which we'll impact in a second. And I wanted to keep this discussion, Steve, kind of focus on what operational privacy professionals like chief privacy officers would care about, because that's my kind of community. That's where I come from. I first wanted to ask you, though, you have such an incredible IT background and also just a champion for privacy in general. What actually drove you to become the sponsor and kind of the key individual driving this act forward in Minnesota?
So the very first version of this bill was actually brought to me by the local lobbyist for Microsoft. He had been shopping the bill around, and everybody, all my colleagues, told him that, oh, you should go talk to Elkins. He's the data geek in the legislature right now. And he brought the bill to me. We had a conversation, and I told him, his name is Amos Briggs, a really nice guy. But I said, well, Amos, I can't guarantee you that I'm going to try and pass this bill, but I do agree that I'm probably the best person in the Minnesota legislature to be working on this issue, because I've spent 25 years working as an information architect in a wide variety of industries, and I understand data governance principles really well. And so that was the start. And I only learned later that what he had brought me was the version of the first version of Washington Senator Reuben Carlisle's Washington Privacy Act.
Hmm.
I later met Senator Carlisle, and we became friends. But that was really the genesis of my picking this up at the very end of the session in May of 2019. And yeah, he said it took till 2024 to finally get it across the finish line.
That's great. And speaking of the Washington Privacy Act, I know that you also pulled from other existing state privacy laws like Oregon Consumer Privacy Act when it comes to allowing individuals to obtain a list of specific third parties, New Jersey when it comes to specific opt-out rights for teens, the Maryland Online Privacy Data Privacy Act when it comes to the non-discrimination kind of protections. So Steve, I guess I was wondering in terms of like pulling from other state laws and saying, hey, this looks like a good thing for Minnesota. How do you actually kind of go through that process? What drives you to pick a certain requirement from another state law?
Yeah, so one of the advantages of being 19th is that I had the benefit of looking at what 16 or 17 other states had done before us. Having followed this since 2019, I watched as Virginia first passed a bill based on the Washington Privacy Act template, and then Colorado, and then Connecticut. Actually, I think most of the state privacy laws that passed in the last 2 years or so were largely based on Senator James Maroney's Connecticut bill. He and before him, Senator Rodriguez in Colorado really did a very thorough job of vetting the basic Washington Privacy Act that Senator Carlisle had drafted in both states, that the original framework was significantly improved. I think if you did a careful analysis, you'd find that almost everything that passed after Connecticut passed its laws was largely used that one as a starting point.
Hmm.
But there were a lot of states that passed laws in intervening years. So as you noted, I picked some provisions that were out of Oregon. The definition of a small business came from Texas, and so by the time I got around to finishing my bill, I had a lot of previous work that other states had done before me to draw upon and pick a best of all of the above. So I feel fortunate in that respect. And then, of course, I had to add a few unique things of my own as well,
Yeah.
based on my background.
Yeah, which I want to dive into right now, actually, which is lots of novel things happening in this law. For example, we had talked about the other day the maintenance of a data inventory. So actually codifying a data inventory as a requirement, which I actually feel is a best practice from a privacy perspective. Before we get into other novel requirements, that actually really stood out to me. Why the requirement for a data inventory specifically?
Yeah, so this goes back to my information architecture background, data governance. If you're going to include in your law a right, for example, to have your data deleted, how is the company going to delete your data if they don't know where it is? And I actually had this
100%.
conversation and they were really objecting to this principle. And I said, and I was talking to their primary lobbyist in this, Ron Barnes, who's a good guy, but I said, Ron, you mean to tell me that if I reached out to you guys and said, I want you to delete my data, you wouldn't know where to find it? It's pretty basic.
One question on the data inventory, kind of getting in the weeds a little bit, Steve, is some data inventories, they're not all created equal, right? So some data
So
inventories
for
might
a
have.
small company, it might be just a data dictionary in a spreadsheet.
Mhm.
But for a large company, certainly for Google, what you would expect to find is what we in the trade would refer to as an enterprise metadata repository, where all of the data's inventory is cataloged basically.
Mhm.
I spent the last 7 years of my career at a division of United Health Group, which developed a very comprehensive inventory of all of the hundreds, if not thousands, of databases that the parent company and all of its numerous subsidiaries had, just because they needed to know where the data was so that they could protect it, because the healthcare
Mhm.
industry is under constant cybersecurity threats. And if they didn't know what data they had and where they were keeping it, they would have no way of protecting it adequately.
So if I could play that back for my own kind of clarity, Steve, the specificity and complexity of a data inventory should essentially be commensurate to the maturity of the organization, right? So if it's a small business, maybe a simple data dictionary would suffice,
If
but
it
if you are a Google or a larger organization, you should have a more complex and thorough inventory. Is that how you're
You
saying it?
should. And I think if you're, a small business in this day and age, more and more companies of all sizes, but especially small businesses, are you relying on applications in the form of software as a service. So if they're using Salesforce as an example, they should expect their software vendor to be supporting them in that. And having worked with Salesforce myself during my industry career, that Salesforce has a pretty good metadata capability. So I think a lot of the burden for this is going to end up falling on some of the software as a service vendors.
That makes sense. Wanted to dive into other novel requirements with Minnesota, one of them being the first state to offer the additional right to contest the results of profiling. So not just opting out of automated decision making, really novel. Also, this, I would say it's an implicit requirement to have a chief privacy officer since you have to name who that chief privacy officer is or the equivalent. Let's talk about that one specifically. So obviously on the other side of the Atlantic, we have the GDPR, which requires a data protection officer. And I think obviously some other states do require someone named to be responsible for data protection
Yeah.
efforts. Where did that specific requirement for a CPO or equivalent really, what drove you for that specific title to be actually named in documentation? Just out of
Yeah,
curiosity.
no, I think you hit the nail on the head. If nobody's responsible, there really needs to be someone that is accountable for making sure all of this stuff happens. And certainly, most companies of any size already do have a named chief privacy officer in their compliance department. If you're a smaller company, you might not have a person who's dedicated solely to that role, but there still needs to be someone who is responsible for making sure that these laws are complied with.
Yeah, makes total sense. One one of the other novel requirements that I wanted to hit on, given its operational impact, is the DPPA, or the Data Privacy and Protection Assessment. I think some folks think it's more prescriptive than other kind of impact assessment requirements. Requires, for example, whether or not you're using sensitive data and the context of the processing. You also require a description of the policies and procedures that we've presumably implemented. Can you talk to me about how these prescriptive requirements came to be? Again, is it simply because, like, did you have any dialogue with operational folks around existing impact assessment frameworks, or
Yeah,
is
so
it really
they
based on your background as an IT professional as well, Steve?
largely the latter. What I have observed is that if you can't describe what your policies are with respect to things like data minimization, data retention, you're probably not doing them. So the primary objective was just to force companies to be mindful about, are we really doing these things or not? So, objective wasn't just to, put together a long list of specific requirements. It's just, it's my primarily there just to, so that companies just have to be mindful about, whether they're actually doing any of these things. If you can't write a paragraph about your data retention policy or your data minimization policy, you probably don't have one.
Absolutely. And I think the requirement to codify and formalize a lot of these policies is actually really, I mean, to your point, as a mature company, we should already have a lot of these in place. And so a law like Minnesota's is simply saying,
Follow
we're now
best
requiring
practices.
that. Exactly. Yeah. Steve, switching gears a little bit, I know you mentioned that some of these state laws could preempt federal standards. And obviously, we're still waiting for a federal privacy legislation. I think every privacy professional is kind of waiting with bated breath. I don't think it's going to happen in this administration. I don't think anyone thinks that's going to happen anytime soon. But do you see Minnesota's law becoming kind of a template or a basis for a federal privacy standard?
Well, I think that, we've now had a couple of false starts in Congress on attempts to do federal privacy legislation. I actually thought the American Privacy Rights Act last year was a pretty good framework. In, some respects, it was an improvement upon the existing state standards. So, for example, at the state level, starting with Virginia, we tended to get all of our undies wrapped around the axle over the issue of what constitutes the sale of data. And in the APRA, they, dispensed with that entirely. And instead of talking about sale, they just had it was going to apply to all sharing of data. Much, much simpler and straightforward, completely dodge that whole discussion about what constitutes a sale. So I think most of us at the state level are okay with, we would actually like Congress to pass a federal data privacy act. And I think that we would hope that, the Congress would look at what's been happening at the state level, because as you've observed, there is a high degree of commonality in all of our state laws, because 18 out of 19 states, built upon the Washington Privacy Act framework.
Mhm.
And so all of the basic definitions, the basic rights and responsibilities are pretty common across all 18 or even all 19 of the states that have passed these laws. So we can talk about, the patchwork, but there really is a high degree of commonality and the rights and responsibilities that are required in all of the 19 state laws that have passed so far.
100%. Switching gears to enforcement now, Steve, as we've seen, Texas has come out swinging with its enforcement activity recently against Allstate. We also have the California Privacy Protection Agency with recent enforcement actions against Todd Snyder, Honda, and others. Do you foresee the Minnesota State AG being as active? Can you tell me a little bit about maybe what you anticipate them focusing on as well?
Sure. Yeah. With the effective date of the act coming up very shortly here, I've been working with the Minnesota AG's office on enforcement strategy. Part of what we're thinking of is we're recognizing that I think I've got them an additional like three or four people in my bill. Again, because there is so much commonality across these state laws, there are going to be a lot of areas where the state AGs are going to be pursuing enforcement cooperatively across states. So a lot of the provisions where that are in common, I expect multi-state enforcement. So there's a couple of things that we're focusing on that are kind of very important in Minnesota right now, or things that are unique about my bill. So you had touched upon example some of the provisions related to profiling, and we should probably talk about this a little bit more in the AI context as well, because it relates to my perspective on the way AI regulation should be approached, especially with respect to profiling or automated decision making. But in our act, we provided, in addition to the right to opt out of having your data profiled, I put in a provision that says that if your data is profiled, you've got the right to question the results of the profiling, to look at the data that was used to profile you, have it corrected if there are errors in it, the right to have an explanation of why you got the decision that you did. And I built all of this pretty much based on the rights that we already enjoy with respect to our credit scores under the Fair Credit Reporting Act. So, if you can go into, if you have questions about your credit score, you can go into Credit Karma or Experian or TransUnion, and you can look in there and you can examine the data that was used to calculate your credit score. If you see errors in it, which I've done, by the way, you can ask that those errors be corrected and your score be recalculated. You can go in and I can see that, 35% of my credit score is based on the fact that I always pay my bills on time. 25% is based on what percentage of my available credit I'm using, and so on. And I just think that those kinds of rights ought to be generally available for other, legally consequential decisions related to employment or insurance or housing. A good example of a friend who's actually a privacy professional himself, who applied for an apartment and was turned down based on a profiling algorithm. When the guy probably makes $500,000 a year, no criminal record or anything, no objective reason why he should be being turned down for an apartment. But when he asked the apartment broker why he was turned down, he was just told, it's proprietary. I'm sorry, that's not an acceptable answer. The guy deserves to know why he was turned
Hmm.
down for an apartment despite his stellar credentials. So I think that's going to be that's unique to Minnesota. Actually, I think Connecticut has now copied that provision now as well. But we were the first state to do that, and so I think we'll be looking at that an enforcement priority. The other one, of course, we had a tragic assassination of one of our legislative leaders about a month ago. And as a result, every member of the legislature has been provided a Delete Me account. And there's been some really good recent reporting by Consumer Reports in particular, indicating that many data brokers of, Find Me type services are not honoring the deletion requests that are being submitted through third parties like Delete Me. So that's kind of top of mind for us right now. So I volunteered to be a guinea pig, and we'll be following up by, and actually we're going to be working with Delete Me in this case. I've got a meeting set up with them on Friday, and we're going to cooperatively look at the services that Delete Me is monitoring, is requesting deletions from. And if one of our deletion requests submitted through Delete Me has not been acted on, we'll be going after those brokers.
Incredible, Steve. I think everything you've said is so incredibly consumer protective, pragmatic. So it's quite refreshing to hear. Pivoting to AI, we can't have a conversation about privacy without AI. It's on top of everyone's mind. Above and beyond the profiling measures that you had talked about, is your office also looking into kind of similar provisions that are coming out of California around maybe watermarking or transparency? Any AI specific bills that you are having a hand in?
Yeah, so I think I view that profiling provision in many respects as an alternative to the way many states are approaching the use of AI for automated decision making. I think a lot of that legislation that I'm seeing is very technically naive. Going back to, I'm an economist by education. I used to set airfares for a living and was very involved in the development of the early decision support technologies around pricing and revenue management. So I understand the decision support space really well. And I don't, I don't think that AI as a family of technologies can be defined well enough to legislate around. And I don't think you should try. So when I was first embarking on this quest, one of my first stops was to the guy named Bill McGovern. He's currently the dean of the University of Minnesota Law School. At the time, the reason I was directed to talk with him is that he had literally written the textbook on data protection and data privacy law that is used in 20 law schools around the country. And so I was lucky enough to get some time with him at the beginning of my quest. And I think probably the most important lesson that I learned from Dean McGovern was that he said, Steve, don't ever try and regulate technologies themselves. They change too rapidly. Regulate the use cases. And the example that he used was just wonderful. I love telling this story, but he related that the transition from horses to cars, which most people don't realize, mostly occurred over about a single decade between about 1910 and 1920.
Mm.
And he said. The tort law couldn't keep up. And so, what the courts resorted to doing is treating cars as if they were horses. And he said, Steve, what you have to do if you're going to regulate in around technology is you have to be able to write laws that are robust enough to survive a transition in technologies equivalent to horses to cars. And I look now at and I see laws being written saying you can't use AI to make decisions about claim denials in healthcare, for example. But there are so many definitions of AI. I think you touched on this in your last interview with Keir Lamont and Tyler Bridgerton as well. But I don't think you can define AI, at least for this use case, in a way that a judge or jury would understand whether a particular technology is constitutes AI or not. And I don't think it matters if, people have been using artificial intelligence in the healthcare industry, which, I spent the last 10 years of my career in for decades to make decisions about approval of prior authorizations, what's called risk stratification, which is where
Hmm.
you try and identify patients who are in need of special interventions. And to me, it's very obvious that in many cases, what companies are calling AI in their marketing literature isn't really anything that an AI professional would call AI. It's just the
Hmm.
same kinds of statistical analysis techniques that have actually been out there in the marketplace for 50 years.
Exactly.
So if a professional can't tell where multiple regression analysis leaves off and artificial intelligence begins, how is a judge or jury going to do that? So I wrote that profiling provision in my bill. The way I did is that I did not want to make any references to technology. So the term profiling, as it's used in the 19 state data privacy laws, encompasses the use of AI. It's a broader term than automated decision making using AI, as you see in some of the state bills right now. And so I don't need to write a special law or an additional amendment to my privacy law to cover those scenarios because it's already covered. All of the protections in terms of discriminatory use of the data, those are already exist in our state data privacy laws because there isn't
Mhm.
anything in a particular decision support technology that is the bias gets introduced by the choices that the modeler makes about what data to include or not include in the training of the model.
Absolutely. And Steve, I think your comment around existing privacy frameworks applying to AI technology is quite apt. Obviously on the EU side, everyone is kind of fretting about the complications and essentially the obligations of the EU AI Act, right? However, the GDPR still applies to those processing activities. So we still have a framework to work with. And I love that horse and car analogy, quite useful. Steve, last question for you. Yet the other day, our CEO Ben Brook gave you a walkthrough of the Transcend platform, so you were able to see how a platform like ours connects to data systems and actually automates privacy controls for compliance with potentially Minnesota and the other 18 state laws. I was wondering if there was anything about our functionality that or a platform that might have stood out to you. And the second part of that question would be, do you see a platform becoming table stakes for any company to be able to comply with the 20th privacy law that comes into play?
Yeah, I think for a company of any significant size, that's definitely the case. I mean, when I was working at United Health Group, the UHG already had an enterprise metadata repository. They had enterprise data profiling tools. I worked on projects, for example, to say one of my assignments was a project for the Optum division that was to find any place in any database in any Optum subsidiary that might hold a social security number. And so we were able to just query the enterprise metadata repository and say, find me any column that includes any variant of the spelling of social security number and make me a list. And we used that list to send a letter to the CIO and CEO of every subsidiary saying, we think you might have a social security number in this column, in this table, in this database. You've got a month to look to see if there's anything there. If there is, either delete it or tell us why you can't delete it. And if you can't delete it, tell us how you're going to encrypt it. Any large company ought to be able to do something like that. And it's harder now. I mean, the way that UHG was able to do it, because when they made an acquisition, and they make acquisitions all the time, they would immediately, one of the first things they would do is bring all of the acquired company systems inside the UHG firewalls into a UHG cloud so that they could regularly scan all of those databases and collect this information. Today, with companies increasingly reliant on software as a service, you can't do that kind of thing anymore. And so the platform that you guys are providing, I'm very impressed with, allows you to go off into and look for the metadata in these software as a service applications like a Salesforce, for example, and pull it all together. And what I saw when you demoed the platform for me the other day, it covers just about every requirement I've got in my data privacy law. It's kind of one stop shop. I was very impressed.
Thank you so much for this opportunity. I'm excited for July 1st, and I'm sure all my peers are going to appreciate the insight that you've brought today. So thank you so much.
You're welcome. Thanks for the opportunity.